quickly, your reaction to the 6-3 Supreme Court decision. Basically, what the majority is saying is that Biden just did not have the authority to do this. Do you agree?
I don't agree with the court's majority, and I do agree with the president here. The HEROES Act, which is the piece of legislation that President Biden relied upon to put forth his student debt relief plan, specifically talks about the ability to, quote, waive or modify student debt obligations. Certainly, student debt relief, to me, counts as waiving or modifying that obligation. And you mentioned earlier about how the majority used this major questions doctrine, which is something that the conservative supermajority on the Supreme Court has kind of come up with in the last couple years to say that when Congress speaks, if the executive branch then uses that congressional authority to do something that's important politically, economically, socially, then Congress needed to say that specifically. Now, look, the law that the president used talked about being able to waive or modify these loan obligations in cases of national emergency. That seems to be pretty specific to the situation here, and yet this conservative supermajority on the Supreme Court said it wasn't good enough. But as Justice Kagan said in her dissent, that's really the majority substituting its own judgment for Congress's judgment, which gave that flexibility in decision-making to the executive branch.
Well, so, Elizabeth, the president's taking a new approach here. He addressed the American people a short time ago, rolling out a new path following the decision. Take a listen to what he said, and we'll get your reaction.
I'm announcing today a new path consistent with today's ruling to provide student debt relief to as many borrowers as possible, as quickly as possible. We will ground this new approach in a different law than my original plan, the so-called Higher Education Act.
The Higher Education Act. We know that progressive Democrats were pushing him to do this before he actually made the move that the court just struck down. What does that actually mean? How can our viewers understand the difference between what we had before and this new approach? Will it work?
Well, hopefully there will be no difference when it comes to the actual, impact on borrowers who are under crushing debt, in the sense that hopefully it will achieve the same results as the original student debt relief plan. And I think the president is right to try different ways of achieving his policy goals. Just because the Supreme Court said in its ruling today that this was not an appropriate way to do it, I think that's totally wrong. But, the president is right to go back to the drawing board and say, this is important for me to do for the American people who have struggled during COVID, who are struggling under the crushing weight of student debt. And I'm going to use the authority that I'm given under the law to try to make things better. That's his job.
But when the first law he used this to, and underpinning his argument, was the HEROES Act, which means there would have to be some sort of national emergency. But what we also know is that the COVID-19 pandemic as a national emergency has ended. So even the pause on student loans, those are going to start now in the fall. You have to pay them again. So is the president using this national emergency for the bedrock of the decision of forgiveness? Does that make sense now, given it's been lifted?
Well, I do think that, just as a practical matter, just because the COVID pandemic national emergency was declared to be over, doesn't mean the effects of it are completely over, and the lingering effects of it are not completely over. But, that's why he's also looking to the Higher Education Act. It's a different piece of legislation that gives different authority. And so, there are multiple ways to go about reaching this end. And is there a chance that it will be challenged in court? Probably. There seem to be a large number of conservative activists. In this particular case, it was conservative states who want to, for whatever reason, not see this debt relief given to these everyday Americans who are suffering under this burden, even though, as the president himself noted in his remarks, plenty were very delighted to support loan repayment and forgiveness to businesses during COVID.
Yeah, right. So again, Annmarie, you set that up. It goes to court. It follows him through the entire campaign.
Yep.
And he can say that he's still fighting it. With yesterday's affirmative action ruling in mind here, Elizabeth, the court basically told us this week that a business can reject a customer because they're part of a protected class, but a university cannot accept a customer because they are part of a protected class. How do you rationalize those two?
I think it's really difficult to rationalize those two. It's certainly a very odd vision of the equality and freedom guaranteed under the Constitution. You know, and to be clear, my organization filed a brief in both cases, but we certainly know, if you look at the history of the 14th Amendment, which guarantees equal protection to all persons in this country, that the idea that equality is guaranteed by our Constitution is not something that's just declared by fiat and then, you know, never given any attention or cultivation in the future. The drafters of the 14th Amendment were arguably the originators of affirmative action because they put in place programs that were intended to, you know, after abolishing chattel slavery, then try to create genuine, meaningful opportunity, particularly for Black Americans. And so the idea that you can't try to create opportunity, that there's just this, you know, as Justice Sotomayor said in her dissent, let them eat cake obliviousness, color blindness for all that we saw in the majority's opinion striking down affirmative action has no basis in the Constitution.